I don't get it. Like, what's wrong with just giving? I did 6.5 years straight. What's wrong with just giving me my time served? Give me whatever restitution. I don't care if you charge me.
Nobody has nobody, sir.
When you guys, Washington County did not come get me from the MDOC for this case. What are you
Mr.
talking
Duncan,
about,
let the judge finish.
They're telling me I gotta put $1,500 up. Fuck my motherfucking dick, man. And I smack my.
What begins as a routine court session in Judge Simpson's courtroom quickly turns into something far more chaotic when two adult defendants begin acting as though they understand the law better than the judge presiding over their cases. Instead of approaching the hearing with caution, one of the men seems determined to argue his way into a more serious legal situation simply to avoid basic probation requirements. The other appears convinced that a few years of personal research has made him immune to the court's authority. Their confidence is unmistakable, but their judgment appears questionable. As the exchange continues, the tension in the room slowly builds while the judge's patience is clearly being tested. Moments like this highlight how quickly a courtroom can shift from calm procedure to open frustration when defendants refuse to cooperate. It leaves observers wondering which of the two will ultimately create the bigger problem for themselves.
Cause case, People versus Corey Duncan.
Amber Harris within on behalf of Mr. Duncan. Mr. Duncan, if you are present, can you please unmute and state your name for the record?
Corey Duncan.
Your Honor, we are also asking for an adjournment in this matter, just to finish discussing any plea negotiations.
Why aren't these discussions finished?
Well, I have spoke with Mr. Duncan, and I know what Mr. Duncan is looking for. I reached out to Ms. Kirby in regards to Mr. Duncan's matter. I just have to see if Mr. Duncan would accept what Ms. Kirby is offering. I have had conversations with him, and it's just certain things that he doesn't agree with.
May 18th, 2022, 9 a.m.
Can I say something?
Yes, sir. If you want to, sir.
Basically, at the last court proceeding, there was like the breakout room where the discussion of time served.
Well, hold on, sir. I don't want you discussing anything on the record or with me regarding anything that you may have discussed with your attorney. So I'm going to stop you from saying anything at this point because all of those are privileged communications and I'm not going to have you blurt them out. All right.
I got to come back May 18th.
Yes, sir.
Listen, I don't understand like why this is like being drug out like this in any way, shape, or form.
Sir, all right. Hold on. I adjourned it the last time. I got a request for an adjournment this time for further discussions. My understanding is that there has been communication going on between counsel. So the only thing that I can do is attempt to try to give you another date so all of that can happen, and hopefully there'll be a resolution to the case.
I'm saying I already did my time for this case. Like I got to go to work, and every time I'm not even at work right now because I have to get on this screen because you guys keep adjourning.
Mr. Duncan.
During the hearing, one of the defendants repeatedly interrupts the judge to complain about how probation requirements might interfere with his work schedule. In a courtroom setting, that approach rarely helps a defendant's position. When someone is facing potential jail time, arguing about personal scheduling can come across as missing the larger picture. Each time he talks over the judge, the atmosphere in the room grows more tense. Respectful communication is essential in court, and interrupting the person who holds authority over the decision being made rarely leads to a favorable outcome. If the goal is to appear responsible and cooperative, the first step is usually demonstrating patience and respect. Courtrooms are designed for legal proceedings, not for negotiating personal inconveniences.
I don't get it. Like, what's wrong with just giving? I did 6.5 years straight. What's wrong with just giving me my time served? Give me whatever restitution. I don't care if you charge me.
Nobody has said any of that to me. I am not part of those.
That's what it was discussed at the last court date.
I am not part of those discussions. By design, I'm not part of those discussions. So you have to talk to your attorney. He's talking to the prosecutor. You get on here.
That's not even my attorney. Like, I don't even understand how this attorney is representing me, like right now.
All right, look, I am not the one to try to resolve those issues with you. If you want to,
how do I get another attorney? Because this attorney's calling me the day before. There's a conflict of interest somewhere.
Mr. Duncan.
I don't know what. Mr. Craigo, let me put you and him into a breakout room because you can tell him what I'm trying to tell him.
Exactly.
He just keeps talking and I'm not getting anywhere.
I got
it.
I'll take care
can you put Mr. Craigo, Mr. Duncan into a breakout room? Or it does call the case or recall the case, People versus Corey Duncan.
On behalf of the people.
Assistant Public Defender Brian J. Craig on behalf of Mr. Corey Duncan. Mr. Duncan, unmute yourself and state your name for the record, please.
My name is Corey Duncan.
Thank you, Your Honor. I appreciate the opportunity to speak to Mr. Duncan in the breakout room. At this time, my client would like to tender a plea of guilty under the offer that has been extended by the prosecution in this case. And it would be a guilty plea to count one in this matter. Count two would be dismissed. We agree that the restitution would be $1,500, and my client is rejecting the offer of HIDA because he does not wish to be placed on a period of probation.
The situation becomes even more surprising when the defendant rejects what appears to be a relatively manageable requirement, simply checking in once a month as part of probation. For many people, that condition would be seen as an opportunity to keep a clean record and move forward. Instead, he treats the obligation as if it were an unreasonable burden. From the outside, it looks less like confusion and more like a refusal to take responsibility. Sometimes individuals gradually move towards serious consequences through small poor choices, but in this case the path seems unusually direct. By dismissing a simple condition meant to help him avoid larger penalties, he unintentionally increases the risk of facing harsher outcomes.
Is that your understanding, Mr. Duncan, of how you wish to proceed today?
Yeah, I mean, there's the whole intertwined process.
Is that a yes or no? Is that how you want to proceed?
I mean, I want to just make sure it's like clear as to why I don't want the HIDA. Like that way, there's a understanding there. I don't know if we can do that after or before.
Your Honor, I think there's been a clear breakdown in communication, so we will again revisit the adjournment. Mr. Duncan wished to resolve it today. We had a lengthy discussion about that. It appears that he is now changing his mind. So we will ask for that adjournment so he can come back and speak
what are
to.
you talking about, man? That's not what I'm saying.
All right, look, folks, I just have to make sure everybody's clear. Mr. Duncan, just listen to me. And that is that if there's restitution which is involved, and I get you may want the time served and maybe not want the probation. I don't know if that's it. I'm just gleaning from telling me. If that's the case, that's going to be unlikely unless that probation is paid up front, or unless the restitution is paid up front. If there's going to be a claim.
This 6.5 years. When you guys,
Sir,
Washington County did not come get me from the MDOC for this case. What are you,
Mr. Duncan,
about,
let the judge finish.
They're telling me I got to put $1,500 up out the gate. Otherwise, you
I
can't
don't
get the time
know.
served.
That's what was said. I didn't say. That out the gate. I just said if it's going to be paid over time, that's what's going to happen. I mean, you can listen to me or not listen to me. Fight with me if you want. It doesn't matter to me. May 18th, 2022.
No, I'm not coming back, man. You can suck my motherfucking dick, man. And I smack
Mr. Duncan, stop talking, Mr. Duncan. Thank you, Your Honor.
Jeez, oh, that was enjoyable. All right, 14 a.m. stand in recess.
Thank you, Your Honor.
At another point, the discussion shifts toward financial concerns, and the defendant begins raising his voice about money during the sentencing conversation. The judge is explaining the legal consequences and available options, but the reaction suggests the defendant is approaching the situation like a dispute over fees rather than a criminal proceeding. In a courtroom, the focus remains on the law and the responsibilities that come with it. When someone treats the process like a complaint line for personal grievances, it can make the situation worse rather than better. Judges evaluate behavior as well as facts, and the way a defendant conducts themselves during a hearing can influence how the court views their level of accountability.
Court calls the case, People versus Corey Duncan.
And may we approach briefly, please?
All right, we're back on the record in the Duncan matter. Suffice it to say, my understanding is there'll be a motion to withdraw coming. I'm not going to go through the rationale or the reasons on the record. I will indicate that that's forthcoming. I am going to then adjourn this matter out so I can hear that motion and or sign it on paper. I will adjourn it out to June 8th. 2022 at 9 a.m. This proceeding, as I had indicated the last time, the defendant is ordered to appear in person to the court. So we can, Ms. Kleeman, you can let new counsel know or whatever. I won't issue a warrant at this time because I ordered it for this hearing and he is not here in person, but I'm ordering it for the 8th because apparently he's got something he wants to say to the court. So we'll do it in person, face to face. Thank you. Bond, continue.
Eric Anthony Vermeulen.
Gotcha.
Your Honor, this is just a driving while license suspended. I know Mr. Vermeulen, we don't have updated contact information for him to get in contact with him. The number that is on file belongs to someone else. So I have not been able to reach him in regards to this case. So I'm unsure if he does have a valid driver's license at the moment.
He does not have a valid
Can you
driver.
hear me?
Yes, we can hear you, Mr. Vermeulen.
Okay, good. Thank you. I'm not good with these phones. I don't have a valid driver's license, and I want to apologize for taking the court's time up, but I've done everything that I possibly could to this point to try and satisfy the court. I have other dealings with another court, and they're not letting me move on. They got me set up.
He muted. Eric, you muted. Eric? Okay.
Yes.
All right.
Yes, Your Honor, you there?
Yeah, I'm here.
Okay, someone tried to call in and it's all making all this noise. I'm sorry. So I want to apologize for taking the court's time and please understand I've done everything to satisfy the court, both courts. And now they have me set up for another final settlement. This is my fifth one. And I don't know why they're doing that.
What court are you in?
This is the Saline Court in Saline. I think it's 14.
Okay. Have the people at 14A4.
Okay.
Have the parties worked together to try to figure out what's going on at 4 as opposed and with this?
Yes, Your Honor. If I may, Assistant Public Defender Brian J. Craigo, I was representing at the time Mr. Vermeulen at 14A4 District Court before Judge Freshour, and he was before the court yesterday. He terminated the services of the Public Defender's Office. It's been a multiple times where we've been appointed, we've been removed from the case, and this is the third iteration. We were removed again at the request of Mr. Vermeulen. It was set for final settlement conference by Judge Freshour. I believe it will be for the August date in which he is again terminated the services of the public defender.
Your Honor, the reason I've been terminating the services is because this is my case and I'm going to suffer or I'm going to not. And I feel that public defenders should work for me and they're trying to make my case for me. I asked them to file a motion and they did not. And they told me it's frivolous. Well, this is my case. I wanted them to file a motion. I feel it's not frivolous and I have other ways to get even talked about it.
Eric?
Yes, sir.
How long have we been going around and around with each other?
Oh, man. Quite a bit.
Okay.
But I don't want to go around and around.
But just listen.
Okay.
So you wanted to file a motion.
Yes,
they were
sir.
telling you it was frivolous. You don't think it's frivolous, right?
No, right.
So in all this, it's got to be almost 2 decades we've been dealing with each other.
Right.
So at what point during that time did you pick up your law degree?
I didn't, but honestly, I've been studying law for 2 years, believe it or not.
Eric.
Yes, sir.
What do you want me to do?
I want you to please adjourn the case, and I would say as far as 3 months out, because
that's not happening.
Eventually, the exchange reaches a point where the defendant leaves the courtroom, and Judge Simpson remarks that his departure was enjoyable. In courtroom language, that comment carries more meaning than it might initially appear. It signals that the judge is relieved to move forward after a tense and unproductive interaction. Sometimes silence and cooperation can accomplish far more than constant argument. In this case, the most positive moment of the defendant's appearance may have simply been the moment he stopped speaking. When the highlight of a hearing becomes someone finally exiting the room, it often says a great deal about how the entire exchange unfolded.
Well, I'll have to have 2 more dealings with the Saline Court, I believe. And I believe that would be a reasonable amount of time to take care of this because they set these about a month and a half out. I'd love to take care of business with you, Your Honor. Please understand I'm keeping in touch with you, and if we just put it aside.
Eric, I can't do that. This case has been going on.
Mom showed me how to turn things up and stuff. You just turn this up.
Yep.
I don't know.
Perfect.
Oh, you still there? Oh, Lord. Okay, here's what I'm going to do.
These phones. Can you hear me one more time?
Yeah, I hear you.
Okay, there you go.
All right, Eric.
But I don't know what to do. I mean, I've called, I've done everything, and it's just I have to get through this court case to get things solved out, and then maybe a little bit more.
Okay, Eric. Here's what I'm going to do. You need to talk with your attorney about this case.
Sir. You're kind of breaking up, but
yeah, it's not me. But you need to talk with your attorneys on this case and figure out how you're going to resolve. I'm going to give you till June 8th. You need to come back with a resolution on this.
June 8th. You know, I don't believe that's going to be ample time because I'm
Okay,
set out.
Eric,
I do want to apply,
Eric.
comply with you.
Eric.
Yes, sir.
All right. Put your law degree away. Talk to your attorneys. Come back and see if you can get this resolved.
I've talked to my attorneys, and I hope they understand this is my case, and I have to
Eric.
Yes, sir.
They don't have to understand anything. You need to
Okay,
listen. This is what
okay.
happened last time you got convicted. You started doing stuff on your own.
Right. I understand.
back when you shot the 3 deer with 1 bullet. That was your whole defense, right? Remember?
I understand.
Yeah.
Yes, sir.
So how'd that work out for you?
That didn't work out very good
Yeah,
at all.
it didn't. It didn't
That's
work
probably
out
the
well
worst thing that
at
happened
all
to
for
me.
you. So this is going to head the same way. You're
that
trying
was the
to
worst thing that happened to me.
Eric, you're trying to
Yes, sir.
resolve these driving while license suspended with that 1 bullet theory. Stop it. Listen to your attorney.
I'll listen to him, but I hope you please listen to me
Eric,
too.
I'm done.
Yes, sir.
I'll see you on the 8th.
Very good. I'll see you then. What date, time? The 8th of June, and time is?
You'll get a notice with the time.
Okay, I'll follow up if I don't.
Usually that comes from your attorney. So you'll get it in this case. The 14-4 case, you may not. I don't know.
Okay. I understand. They tell you got to take care of your obligation. They don't need to remind you. So I understand. I'll take care.
Thank you.
Okay, thanks, Your Honor. Have a good day. And everybody else.
Yeah, too late, but thank you. All right. Let me try. I got to get this arraignment out.
Looking back at the 2 defendants, their approaches revealed different but equally problematic attitudes. One seemed unwilling to follow straightforward rules, while the other appeared convinced that he could out-argue the legal system itself. Both mindsets tend to create serious problems in a courtroom environment. Judges are responsible for enforcing the law, not debating it with defendants who refuse to cooperate. When someone enters the courtroom determined to challenge every instruction rather than work within the process, the outcome rarely favors them. In the end, cases like this often become reminders that confidence alone does not win legal battles. Preparation, respect, and accountability do.